let's look at some more practical advice, and then we come to questions. I'm going to ask each of you maybe your 1-2 key takeaways from your experience with the UPC. What do you believe is like, what should clients know? What should partners know about using the UPC? Jasper, you want to start? You have the microphone.
From my last oral proceedings in Paris, central revocation action at the Central Division in Paris, I was once again reminded what front-loaded means. The Central Division in Paris is not even willing to listen to arguments based on different paragraphs of D1 if you haven't mentioned that paragraph in writing before. So this is quite unusual for an attorney to basically put the arguments on the table and then have a discussion. I sometimes get the feeling, what is the point of the oral proceedings if the only thing I can do is repeat myself? But this really, front-loaded means front-loaded. Put everything in writing, don't leave anything out. Cite every freaking paragraph that comes to mind, because there won't be a chance later to do it.
Nils, do you have anything? You have the microphone. Or Julia, you can.
So just jumping in, front-loaded really is front-loaded. And also from infringement side, it means you have to assert every possible claim, every subclaim of the patent, but also if you want to be clear, if you want just rely on a claim for damages, or if you can you're later precluded from adding a claim for injunction. But also case management-wise, you have to be concerned, and if you require, for example, some tests to prove infringement, you really have to diligently look at the test results, and might also have an extensive test report which allows you to have a fallback position already, because later on you only have very little time. You have to look for auxiliary requests maybe, and if you already prepared your work on infringement prior to filing, it's a great help.
So mine would be, don't lose your access code. So the deal is, I'm not talking about my access code. So what I'm talking about is basically when you get served, you're going to get a huge pile of paper. You're going to get claim analysis and infringement evidence and so forth. And the whole thing kind of might add up to somewhere between half a meter or a meter of documents. And just assume that you get served in France because you're a French entity, but you're kind of head legal department sitting in the US. And of course, everybody wants to get rid of a pile of paper about that size. So what do? You kind of pack this nicely and ship it off to the US. But while you have already done that, maybe talking to a lawyer is not a bad idea. And then any UPC representative is first going to ask you, so yeah, give me the access code. And if the answer is which access code, you might be out of luck. So basically any of these cases, when they first initiate it, they get an access code. It's the front page. It's a single page. It's on there. Scan it. Keep it. It's very important, because this is basically the key that allows us to open the case, to get all the documents digitally. We don't care about that meter. We hope that we never see that meter because we all prefer to work with it on screen. And so that's my big giveaway for you. Think about this access code. It's incredibly important. The UPC system had just changed, so they got rid of this really rotten old system and they started a new one. But 2
years old.
They must have thought about this for a long time. So and they have a new system, but the access code it remains.
Yeah, maybe I may add that you can actually throw away old access codes, even if non-used, because then they are no usable anymore. I found that out yesterday, actually, and no one said us before. Let's say you received 1 week ago an access code, it's no longer valid.
It's because of the system changed.
I spent yesterday morning several hours to use any thinkable permutation of the code. I thought maybe the underlining is a space, or I don't need a space any at all. And I was in communication also with the UPC CMS people, and they didn't also not really know what the problem was.
finally, I received information the old codes do not work anymore. So should you be so unlucky to have received such an access code, let's say 1, 2, 3, 4 weeks ago, it's no longer valid. You will obtain a new one, but there's no standard procedure. Actually, I received a new access code from the CMS people, but they communicated with a competent local division here in Munich, and they provided the new access code and so on. So maybe one key takeaway, the CMS remains a difficult task.
Yeah, maybe one aspect from my side, even though the UPC is a new system, a unified system, it's very interesting how much the judges stay in line with their old national case law. This is true for inspection proceedings, where the countries issue orders that are very much in line with the national inspection proceedings, but also with certain legal aspects. Like Neil said, the topic of exhaustion, for example. We had a case where we knew this would be very, very important, and we chose the local division in Munich, especially because we knew that Dr. Voss had case law that was quite favorable for us. And this was issued before in the higher regional court Düsseldorf. She moved to Munich, and she applied basically one-to-one her old case law from Düsseldorf, which gave the whole matter for us a good predictability, even though this topic had not been discussed in the UPC context before. So that was quite nice. And also with other aspects, doctrine of equivalence and so on, I think if there are some uncertainty, it's wise to see where you want to go. And if the judges that are sitting there had issued case law in the past on a national basis, that would be favorable for your case.
Yeah, maybe to look on the other side of this coin, I think you can also think outside the box with the UPC sometimes, because they make their own case law. So not everything is written in stone. So they're open to hear new ideas, to hear how other countries are doing this. So when you go to the German local division, they are also interested in other countries, especially maybe the doctrine for equivalence. We will see how this will turn out. This is definitely not set in stone yet. We only have case law now, 2 from the Netherlands and 1 from Belgium, I think, and they are definitely different from the German doctrine of equivalence, at least some part. And I was on another conference on Monday where 3 UPC judges were there. And actually, they are all not, well, the 2 Germans who were there, 2 German procedures, they don't like the German BGH approach of the doctrine of equivalence. And they are very, very open to find a better new test for the equivalence and to find other way to go there. Also, same with preliminary measures. So we have from more than 50% of all preliminary measures at the UPC were successful. And that's a quite good success rate. We even heard that the courts are even open maybe to preliminary measures in SEP cases, which was in Germany a non-starter, basically. So yeah, be not afraid to have new ideas, just think outside the box and try something out if you are willing to do this. There are many unbeaten paths which can provide advantages for the parties, for you.
Yes, thank you for these insights. We're now moving to questions from the audience. Give that enough time. Wait, Sean.
Hi, based on your experience so far, what one piece of advice would you give to patent attorneys who draft and prosecute before the appeal and then turns into a unitary patent?
I can make.
How much time do you have?
One piece of advice.
No. I have some. I can give you some general advice. I think so. Drafting and prosecuting was the question, right?
Yeah. What would you change?
Beginning with the drafting. For drafting, I can say similar. I can give you a similar answer. I would also give you when you ask me for the German perspective. What you need in your application actually is not only your technical features as such, you need also most cases explanations why those features have any specific purpose, effect, advantage, call it as you want. What is sometimes very difficult to get granted in the end in Europe is, or to defend in front of the UPC. This is quite much the same. If you have a nice invention, but you did not explain at all what the advantage is, you did not explain it in the original application. If you then add such arguments later, it's very likely that they will say, that's now too late. Maybe the invention was performed yesterday. Also, when you filed or submitted those arguments. So effects, advantages should be in the application during prosecution. This is interesting because there are some, or there's at least one local division, namely here in Munich, which is very open towards file, wrapper, estoppel arguments.
Okay.
So it may very well be that you end up in a situation in front of the UPC where the court says, well, you said during prosecution an apple is not an orange, so you cannot say now an apple is an orange, actually. This is all local divisions, by the way, will consider what you have said during prosecution.
Because overseas prosecution as well, or just European prosecution?
Very likely also, certainly also overseas prosecution, because there is a Court of Appeal decision, or actually I think it was an order, but it doesn't matter, where the Court of Appeal said what was said during prosecution is at least a strong indication of the understanding of the skilled person. So I would say the same applies to a US prosecution file. It would also be considered as a strong indication of an expert or skilled person in the field, how to understand a claim feature. And of course, if you were that person, it's even much more difficult to say, well, it was just nonsense what I said.
Maybe also an added matter, me with my formalistic aspect. So like, I mean, run the whole ladder down, this feature with that feature. It's very important. Also what I kind of like, currently it very much looks like they're going to follow the EPO approach on objective technical problem. But from a German perspective, the problem, they are often very willing to kind of take the problem that you really defined yourself at the beginning. So what I tend to do with my drafting, I try to formulate problems on different level of abstraction. Yeah. So it's kind of in particular to do that, and maybe really like your very particular technical, so this realistic, true problem, try to kind of put it somewhere as well. It might be helpful if you end up with some former German judge.
More questions? Yes, right here. We'll just throw 2 rows in front of you. Yes. Thank you.
Thank you. I will have one question to Andreas about the inspections that he mentioned. I love this procedure even in the local jurisdiction because it provides sometimes it triggers a settlement before the main litigation. So my first question will be if it's possible to implement the national inspection proceeding and then base an UPC action based on the national inspection. This is my first question. Secondly, is it possible to effect an inspection in a non-UPC country and then base an UPC action to trigger a long-arm jurisdiction?
Okay, so first aspect with the settlement, I completely agree to this. During our last inspection, while we were still inspecting, we already had the phone call from the other party asking if the client wouldn't be available for settlement discussions. So that's absolutely our experience. Like I said, we did a lot of them, and maybe 20% ended up in main proceedings, and the rest basically was settled. Your first question, if we do national inspection proceedings and then UPC proceedings afterwards, that's a little bit still under discussion, I think. There are some opinions that say you need to carve out the country where you did the inspection. So if you did it in Germany and you file UPC proceedings, you would basically need to leave Germany out of your main proceedings. But if you are inspecting in a country where you say the sales are small nevertheless, then maybe this might still be an option for you. Inspecting in a non-UPC country is not possible. You would need to do the inspection in a member state of the UPC. But what we did is exactly the other way around. Like I said, we went to the Netherlands because we knew that goods were imported, they were stored there in a warehouse and then shipped throughout Europe. And what we wanted to know is, because the defendant was also sitting in, or had its headquarters in the Netherlands, we wanted to see to which countries they were shipping to. And they were also shipping to non-UPC countries like Spain, Poland, and so on. And if you then file UPC proceedings, you can make use of the long-arm jurisdiction and can also cover these countries for which you would normally need to prove infringement, but this you had already covered with the inspection. And we requested specifically that we also wanted to see if goods were sent to non-UPC countries to cover them later in main proceedings with the long-arm jurisdiction.
Thank you. Any more questions from the audience? It's too much, I know. So.
Is anyone active in UPC actions outside of the 6 people at the front? Or 7? Well, why not?
It's about time.
It's about time, yeah. No, but if there are no more questions.
I have a question.
Yeah.
Is it possible to challenge entitlement at the UPC? So solely entitlement?
No. I don't, correct me, but I don't think there is any proceedings foreseen. There's an exclusive list what you can do. You can, of course, within a proceedings challenge entitlement. That's possible.
So if you want to challenge entitlement of a unitary patent, it has to be a national court.
Good question. Unitary patent.
I think post-grant, the EPC takes you to a national court.
Yeah.
What? Not all. You don't always have to go.
But you can choose Munich because the patent office is in Munich.
Might be, but anyway. So if we get this correct, I think the EPC first takes you to a national court. There you kind of get your entitlement, maybe on the national part, and then the EPO will basically enforce this more or less, like at least from a register level, on the complete patent. That's, I think, the way how it works. But
and I may add, I think this is even written down in the unitary patent regulation. So this is national courts in the end. Depending on, Munich might always be an option, but also depending on the domicile of the thief of the invention.
I mean, what you can challenge, obviously, always is standing to sue, whether the plaintiff actually is entitled to make use of that right.
But that would only be.
But it's not. Yeah, exactly. It's not the entitlement per se, but in that particular case, you can challenge the standing to sue there.
And just to correct, it's not post-grant, it's post-opposition period over, of course. Sorry.
Yeah.
I have 2 questions. The first one is, would the patentee be required to pay a bond for the inspection proceedings? And the second question is, I want to ask, what do you think about the effectiveness of UPC in trying to get settlement and then subsequent a license fee?
I didn't get the second part of the first question, sorry.
How effective do you think the UPC is in getting settlement and then subsequently a license?
The first question.
The first question is whether the patentee would be required to pay a bond for the inspection proceedings?
There are decisions where they needed to post a bond, but in the inspections that I had, we didn't post any bonds. This was just plain ex parte without any bonds. And for the effectiveness of settlements, I mean, you put a lot more pressure on the defendant because of the reach of the injunction and the other claims. I think from our experience, settlement discussions are arising quicker than in the national proceedings, but it also depends very much on the parties. If you have of course big companies that are not willing to settle for some other reason, then no. But in general, I would say yes. At least in the cases that I had the feeling that settlements were triggered faster. I don't know how it is with the rest of the panel, but this was at least my experience.
Yeah, just adding, in particular, if the defendants, maybe smaller companies, for them being a defendant at the UPC, of course, is a bigger threat because it requires a lot of more effort to defend against the UPC action versus defending in national proceedings. So this, of course, is an aspect which can, of course, lead into a quicker settlement.
Also, the reimbursable costs are way higher at UPC proceedings than, at least in comparison to German national proceedings. So in a settlement, you can, of course, deal with that every party just bears their own costs or whatever. And so they can mitigate also this risk maybe early on, even prior to the oral hearing or after the oral hearing. And this might also nudge some settlement decisions.
All right, then. If there are no more questions, thank you so much.